Danyluk v. Ainsworth Technologies, Incorporated, 2001, Supreme Court of Canada. The judgment by the court was delivered by Binnie J. The appellant claims that she was fired from her position as an account executive with the respondent Ainsworth Technology, Inc. on October 12, 1993. She claims that at the time of her dismissal, she was owed by her employer some $300,000 in unpaid commissions. The courts in Ontario have held that she is estopped from having her day in court on this issue because of an earlier failed attempt to claim the same unpaid monies under the Employment Standards Act RSO 1990 CE 14 in brackets ESA or Act. An employment standards officer adopting a procedure which the Ontario Court of Appeal held to be improper and unfair denied the claim. I agree that in general, issue estoppel is available to preclude an unsuccessful party from relitigating in the courts what has already been unsuccessfully litigated before an administrative tribunal, but in my view, this was not a proper case for this application. A judicial doctrine developed to serve the ends of justice should not be applied mechanically to work an injustice. I would allow the appeal. Facts. In the fall of 1993, the appellant became involved in a dispute with her employer, the respondent Ainsworth Technologies, Inc., over unpaid commissions. The appellant met with her superiors and sent various letters to them outlining her position. These letters were generally copied by her lawyer, Mr. Howard A. Levitt. Her principal complaint concerned an alleged entitled to commissions about $200,000 in respect of a project known as the CIBC Land Project, plus other commissions which brought the total to amount $300,000. The appellant rejected a proposed settlement from the employer. On October 4th, 1993, she filed a complaint under the ESA seeking unpaid wages, including commissions. It is not clear on the record whether she had legal advice on this aspect of the matter. On October 5th, the employer wrote to the appellant rejecting her claim for commissions and eventually took the position that she had resigned and physically escorted her off the premises. An employment and standards officer, Miss Caroline Burke, was assigned to investigate the appellant's complaint. She spoke with the appellant by telephone and, on or about January 30th, 1994, met with her for about an hour. The appellant gave Miss Burke various documents, including her correspondence with the employer. They had no further meetings. On March 25th, 1994, more than 6 months after filing her claim under the Act, but as yet without an ESA decision, the appellant, through Mr. Levitt, commenced a court action in which she claimed damages for wrongful dismissal. She also claimed the unpaid wages and commissions that were already the subject matter of her ESA claim. On June 1st, 1994, solicitors for the employer wrote to Miss Burke responding to the appellant's claim. The employer's letter included a number of documents to substantiate its position. None of this was copied to the appellant. Nor did Miss Burke provide the appellant with information about the employer's position, nor did she give the appellant the opportunity to respond to whatever the appellant may have assumed to be the position of the employer was likely to take. The appellant, in short, was left out of the loop. On September 23, 1994, the ESA officer advised the respondent employer, but not the appellant, that she had rejected the appellant's claim for unpaid commissions. At the same time, she ordered the employer to pay the appellant $2,354.55, representing 2 weeks' pay in lieu of notice. 10 days later, by letter dated October 3, 1994, Miss Burke for the first time advised the appellant of the order made against the employer for 2 weeks' termination pay and the rejection of her claim for the commissions. The letter stated in part, quote, "With respect to your claim for unpaid wages, the investigation revealed there is no entitlement to $300,000 commission as claimed by you," end quote. The letter went on to explain that the appellant could apply to the Director of Employment Standards for a review of this decision. Miss Burke repeated this advice in a subsequent telephone conversation with the appellant. The appellant did not apply to the director for a review of Miss Burke's decision. Instead, she decided to carry on with her wrongful dismissal action in the civil courts. The respondents contended that the claim for unpaid wages and commissions was barred by issue estoppel. They brought a motion in the appellant's civil action to strike the relevant paragraphs from the statement of claim. On June 10, 1996, McCombs J. at the Ontario Court General Division granted the respondent's motion. Only her claim for damages for wrongful dismissal was allowed to proceed. On December 2, 1998, the appellant's appeal was dismissed by the Court of Appeal for Ontario. 2 judgments. A. Ontario Court General Division, June 10, 1996. The issue before McCombs J. was whether the doctrine of issue estoppel applied in the present case. Following Rasanen v. Rosemount Instruments Ltd. 1994, he concluded that the issue estoppel could apply to issues previously determined by an administrative officer or tribunal. In his view, the sole issue to be determined was whether the ESA officer's decision was a final determination. The motions judge note that the appellant did not seek to appeal or review the ESA officer's decision under Section 67(2) of the Act, as she was entitled to do if she wished to contest that decision. He considered the ESA decision to be final. The criteria for the application of issue estoppel were therefore met. The paragraph relating to the appellant's claim for unpaid wages and commissions were struck from her statement of claim. B. Court of Appeal for Ontario, 1998. After reviewing the facts of the case, Rosenberg J.A. for the court identified at page 239 to 40 the issues raised by the appellant's appeal. This case concerns the second requirement of issue estoppel, that the decision which is said to create the estoppel be a final judicial decision. The appellant submits that the decision of an employment standards officer is neither judicial nor final. She also submits that, in the event, the process followed by Ms. Burke in this particular case was unfair and therefore her decision should not create an estoppel. Specifically, the appellant argues that she was not treated fairly as she was not provided with a copy of the submissions made by the employer and thus not given an opportunity to respond to those submissions. In rejecting these submissions, Rosenberg J.A. grouped them under three headings: whether the ESA officer's decision was final, whether the ESA officer's decision was judicial, and the effect of procedural unfairness on the application of the doctrine of issue estoppel. In his view, the decision of the officer in the present case was final because neither party exercised the right of internal appeal under Section 67(2) of the Act. Moreover, while not all administrative decisions that finally determine the rights of all parties will be, quote, judicial, end quote, for purposes of issue estoppel, Rosenberg J.A. found that the statutory procedures set out in the Act satisfy the requirements. He considered Downing and Graydon 1978 to be, quote, determinative of this issue. End quote, page 249. Lastly, Rosenberg J.A. addressed the issue of whether failure by the ESA officer to observe procedural fairness affected the application of the doctrine of issue estoppel in this case. He agreed that the ESA officer had in fact failed to observe procedural fairness in deciding the appellant's complaint. Nevertheless, this failure did not prevent the operation of issue estoppel. At page 252, the officer was required to give the appellant access to and the opportunity to refute any information gathered by the officer in the course of her investigation that was prejudicial to the appellant's claim. At a minimum, the appellant was entitled to a copy of the June 1st, 1994 letter and a summary of any other information gathered in the course of the investigation that was prejudicial to her claim. She was also entitled to a fair opportunity to consider and reply to that information. The appellant was denied the opportunity to know the case against her and have an opportunity to meet it. Ms. Burke failed to act judicially. In this particular case, his failure does not, however, affect the operation of issue estoppel. In Rosenberg J.A.'s view, although the ESA officers are obliged to act judicially, failure to do so in a particular case, at least if there is a possibility of appeal, will not preclude the operation of issue estoppel. His conclusion is based on the policy considerations underlying two rules of administrative law. At page 252. Those two rules are 1. That the directionary remedies of judicial review will be refused where an adequate alternative remedy exists, and 2. The rule against collateral attack. These rules in effect require that the parties pursue their remedies through the administrative process established by the legislature. Where an appeal route is available, the parties will not be permitted to ignore it in favor of the court process. Rosenberg J.A. noted that if the appellant had applied under Section 67(3) of the Act for review of the ESA officer's decision, the adjudicator conducting such review would have been required to hold a hearing. This supported his view that the review process provided by the Act is an adequate alternative remedy. Rosenberg J.A. concluded at page 256. In summary, Ms. Burke did not accord this appellant natural justice. The appellant's recourse was to seek a review of Ms. Burke's decision. She failed to do so. That decision is binding upon her and her employer. The court thus applied the doctrine of issue estoppel and dismissed the appellant's appeal. Relevant statutory provisions. The Employer Standards Act, RSO 1990, CE 14. In this act, quote, wages, end quote, means any monetary remuneration payable by an employer to an employee under the terms of a contract of employment, oral or written, express or implied, any payment to be made by an employer to an employee under this act and any allowances for room or board as prescribed in the regulation or under an agreement or arrangement, therefore, but does not include A. tips and other gratuities, B. any sums paid as gifts or bonuses that are dependent on the discretion of the employer and are not related to hours, production, or efficiency, C. traveling allowances or expenses, D. contributions made by an employer to a fund, plan, or arrangement to which Part X of the Act applies, quote, salaire, ... 6.1. No civil remedy of an employee against his or her employer is suspended or affected by this Act. 2. Where an employee initiates civil proceedings against his or her employer under this Act, notice of proceedings shall be served on the director in the prescribed form on the same date the civil proceedings is set down for trial. 65.1. Where an employment standards officer finds that the employee is entitled to any wages from an employer, the officer may A. arrange with the employer that the employer pay directly to the employee the wages to which the employee is entitled, B. receive from the employer on behalf of the employee any wages to be paid to the employee as a result of a compromise or settlement, or C. issue an order in writing to the employer paid forthwith to the director in trust any wages to which an employee is entitled, and in addition such order shall provide for payment by the employer to the director of administration of costs in the amount of 10% of the wages or $100, whichever is greater. 7. If an employer fails to apply under Section 68 for review of an order issued by an employment standards officer, order becomes final and binding against the employer even though a review hearing is held to determine another person's liability under this Act. 67.1. Where a following complaint is in writing by an employee, an employment standards officer finds that an employer has paid the wages to which an employee is entitled, or has found that the employee has no other entitlements, or that there are no actions which the employer is to do or is to refrain from doing in order to be in compliance with this Act, the officer may refuse to issue an order to an employer, and upon refusing to do so, shall advise the employee of the refusal by prepaid letter addressing to the employee at his or her last known address. 2. An employee who considers himself or herself aggrieved by refusal to issue an order to an employer, or by the issuance of an order that is in his or her view does not include all the wages or entitlements to which she is entitled, may apply to the director in writing within 15 days of the date of mailing of the letter mentioned in subsection 1, or the date of the issue of the order, or such longer period as the director may, for special reasons, allow for a review of the refusal or of the amount of the order. 3. Upon receipt of an application for review, the director may appoint an adjudicator who shall hold the hearing. 5. The adjudicator who is conducting the hearing may, with necessary modifications, exercise the powers conferred on an employment standards officer under this Act, and may make an order with respect to refusal or an order to amend, rescind, or affirm the order of the employment standards officer. 7. The order of the adjudicator is not subject to a review under Section 68 and is final and binding on the parties. 68.1. An employer who considers himself aggrieved by an order made under Section 45, 48, 51, 56.2, 58.22, or 65, upon paying the wages ordered to be paid and the penalty thereon, if any, may within a period of 15 days after the date of delivery or service of the order, or such longer period as the director may for special reasons allow, and provided that the wages have not been paid out under subsection 72.2, apply for a review of the order by way of hearing. 3. The director shall select a referee from the panel of referees to hear the review. 7. A decision of the referee under this section is final and binding upon the parties thereto and such other parties as the referee may specify. Analysis. The law rightfully seeks a finality to litigation. To advance that objective, it requires litigants to put their best foot forward to establish the truth of their allegations when first called upon to do so. The litigant, to use the vernacular, is only entitled to one bite at the cherry. The appellant chose the ESA as her forum. She lost. An issue, once decided, should not generally be relitigated to the benefit of the losing party and the harassment of the winner. A person should only be vexed once in the same cause. Duplicative litigation, potential inconsistent results, undue costs, and inconclusive proceedings are to be avoided. Finality is thus a compelling consideration, and judicial decisions should generally be conclusive of the issues decided unless and until reversed on appeal. However, estoppel is a doctrine of public policy that is designed to advance the interests of justice. whereas here its application bars the courthouse door against the appellant's $300,000 claim because of an administrative decision taken in a manner which is manifestly improper and unfair as found by the Court of Appeal itself. A re-examination of some basic principles is warranted. The law has developed a number of techniques to prevent abuse of decision-making process. One of the oldest is the doctrine of estoppel per rem judicatem. With its roots in Roman law, the idea that a dispute once judged with finality is not subject to relitigation. The bar extends both to the cause of action thus adjudicated, variously referred to as claim or cause of action or action estoppel, as well as precluding litigation of the constituent issues or material facts necessary embraced therein, usually called issue estoppel. Another aspect of the judicial policy favoring finality is the rule against collateral attack, i.e. that a judicial order pronounced by a court of competent jurisdiction should not be brought into question in subsequent proceedings except those provided by law for the express purpose of attacking it. These rules were initially developed in the context of prior court proceedings. They have since been extended with some necessary modifications to decisions classified as being of a judicial or quasi-judicial nature pronounced by administrative officers and tribunals. In that context, the more specific objective is to balance fairness to the parties with the protection of the administrative decision-making process, whose integrity would be undermined by too readily permitting collateral attack or relitigation of issues once decided. The extension of the doctrine of issue estoppel in Canada to administrative agencies is traced back to cases in the mid-1800s by D.J. Lang of the Doctrine of Res Judica in Canada 2000. Modifications were necessary because of the major differences that can exist between administrative orders and court orders in relation inter alia to their legal nature and the position within the state structure of the institutions that issue them. There is generally no dispute that the court orders are judicial orders. The same cannot be said of the myriad of other orders that are issued across the range of administrative tribunals. In this appeal, the parties have not argued, quote, cause of action, end quote, estoppel, apparently taking the view that the statutory framework of the ESA claim sufficiently distinguishes it from the common law framework of the court case. I therefore say no more. They have, however, joined issue on the application of issue estoppel and the relevance of the rule against collateral attack. Issue estoppel is more particularly defined by Middleton J.A. of the Ontario Court of Appeal and McIntosh v. Parent. When a question is litigated, the judgment of the court is a final determination as between the parties and their privies. Any right, question, or fact underlined, distinctly put in issue and directly determined and underlined by a court of competent jurisdiction as a ground for a recovery or as an answer to claim set up cannot be retried in a subsequent suit between the same parties or their privies, though for a different cause of action. The right, question, or fact underlined, once determined and underlined, must be, as between them, taken to be conclusively established so long as a judgment remains. This statement was adopted by Laskin J., later C.J., dissenting in Angle. This description of the issues subject to estoppel, quote, any right, question, or fact distinctly put in issue and directly determined, end quote, is more stringent than the formulation in some of the older cases for cause of action estoppel. Example, quote, all matters which were or might properly have been brought into litigation, end quote. Dixon J., later CJ, speaking for the majority in Angle Supra, subscribed to the more stringent definition for the purpose of issue estoppel. Quote, it will not suffice, he said, if the question arose collaterally or incidentally in the earlier proceedings, or is one which must be inferred by argument from the judgment. The question out of which the estoppel is said to arise must have been, quote, fundamental to the decision arrived at, end quote, in the earlier proceeding. In other words, as discussed below, the estoppel extends to the material facts and the conclusions of law, where there were mixed facts and bracket the questions, end bracket, that were necessarily bracket, even if not explicitly, end bracket, determined in the earlier proceedings. The precondition to the operation of issue estoppel were set out by Dixon J. in Angle Supra at page 254. 1. The same question has been decided. 2. That the judicial decision which is said to create estoppel was final. And 3. That the parties of the judicial decision or their privies were the same persons as the parties to the proceedings in which the estoppel is raised in their privies. The appellant's argument is that even though the ESA officer was required to make a decision in a judicial matter, she failed to do so. Although she had jurisdiction under the ESA to deal with the claim, the ESA officer lost jurisdiction when she failed to disclose the appellant's case. The appellant had to meet and to give the appellant the opportunity to be heard in answer to the case put against her. The ESA officer therefore never made a judicial decision as required. The appellant also says that her own failure to exercise her right to seek internal administrative review of the decision should not have be given the conclusive effect adopted by the Ontario Court of Appeal. Even if the conditions precedent to issue estoppel were present, she says, the court had a discretion to relieve against the harsh effects of estoppel per ren adjudicatem in the circumstances of this case and erred in failing to do so. A. The statutory scheme. 1. The Employment Standards Officer. This ESA applies to, quote, every contract of employment, oral or written, express or implied, end quote, in Ontario, Section 2.2. Subject to certain exceptions under the regulations and establishes a number of minimum employment standards for the protection of employees. These include hours of work, minimum wages, overtime pay, benefits plans, public holidays, and vacation with pay. More specifically, the Act provides a summary procedure under which the aggrieved employees can seek redress with respect to an employer's alleged failure to comply with these standards. The objective is to make redress available where it is appropriate to all, expeditiously and cheaply. In the first instance, the dispute is referred to an Employment Standards Officer. ESA officers are public servants in the Ministry of Labor. They generally not legally trained, but have some experience in labor relations. The statute does not set any particular procedure that must be followed in disposing of claims. ESA officers are given wide powers to enter premises, inspect and remove documents, and make other relevant inquiries. If liability is found, ESA officers have broad powers of enforcement. Section 65. On receipt of employee demand, generally speaking, the ESA officer contacts the employer to ascertain whether, in fact, wages are unpaid, and if so, for what reason. Although in this case there is a 1-hour meeting between the ESA officer and the appellant, there is no requirement for such face-to-face meeting, and clearly there is no contemplation of any sort of oral hearing in which both parties are present. It is a rough and ready procedure that is wholly inappropriate, one might think, to definitive resolution of a contractual claim of some legal and factual complexity. There are many advantages to the employee in such forum. The services of the ESA officer are supplied free of charge. Legal representation is unnecessary. The process moves forward rapidly than could realistically be expected in the courts. There are corresponding disadvantages. The ESA officer is likely not to have legal training and has neither the time nor the resources to deal with a contract claim in a manner comparable to the courtroom setting. At the time of these proceedings, a double standard was applied to an appeal, or as it is called, a review. The employer was entitled as a right to a review, Section 68, but as discussed below, the employee could ask for one, but the request could be refused by the director, Section 67.3. At the time, as well, there was no monetary limit on the ESA officer's jurisdiction. The Act has since been amended to provide an upper limit of claims of $10,000. Had the ESA's officer determination gone the other way, the employer could have been saddled with $300,000 liability arising out of a deeply flawed decision, unless reversed on an administrative review or quashed by a supervising court. 2. The review process. The employee, as stated, has no appeal as of right. Section 67.2 of the Act provides that the employee dissatisfied with the decision at first instance may apply to the director for an administrative review in writing within 15 days of the date of the mailing of the Employment Standards Officer decision. Under Section 67.3, the director may appoint an adjudicator who shall hold a hearing, end quote. The word may grants the director discretion to hold or not to hold a hearing. The Ontario Court of Appeal noted this point, but said the parties had attached little importance to it. It seems clear the legislature did not intend to confer an appeal as of right. Where the directors did not appoint an adjudicator, a hearing is mandated by the Act. Further delay and expense of the ministry and the parties would follow as a matter of course. The juxtaposition in Section 67.3 of may and shall, and in the French text, the instruction of the director, quote, peut nommer un arbitre des griefs pour tenir une audience, end quote, puts the matter beyond doubt. The Ontario legislature intended the director to have discretion to decline to refer a matter to an adjudicator which, in his or her opinion, is simply not justified. Even the adjudicators hearing and review under Section 67.3 of the Act are not by statute required to be legally trained. It is likely considered undesirable by the Ontario Legislature to give each and every dissatisfied employee a review as a right, particularly where the amounts in issue are often relatively modest. The discretion must be exercised according to proper principles, of course, but a discretion it remains. If an internal review were ordered, an adjudicator would have looked at the appellant's claim de novo and would have undoubtedly shared the employer's documents with the appellant and given her an opportunity to respond and comment. I agree that under the scheme of the Act, procedural deficits of the ESA officer level, including a failure to provide proper notice and an opportunity to be heard in response to the opposing case, can be rectified on review. The respondent says that the appellant, having elected to proceed under the Act, was required to seek an internal review if she was dissatisfied with the initial outcome. Having done so, she was stopped from pursuing her $300,000 claim. The appellant seeks that the ESA procedure was so deeply flawed that she was entitled to walk away from it. B. The applicability of issue estoppel. 1. Issue estoppel, a two-step analysis. The rules governing issue estoppel should not be mechanically applied. The underlying purpose is to balance the public interest in the finality of litigation with the public interest in ensuring that justice is done on the facts of the particular case. Bracket, there are corresponding private interests, end bracket. The first step is to determine whether the moving party, in this case the respondent, has established a precondition to the operation issue estoppel set out by Dixon J. in Anglo Supra. If successful, the court must determine whether, as a matter of discretion, issue estoppel ought to be applied. The appellant was quite entitled, in the first instance, to invoke the jurisdiction of Ontario Superior Court to deal with her various monetary claims. The respondent was not entitled as of right to the imposition of an estoppel. It was up to the court to decide whether, in the exercise of its discretion, it would decline to hear aspects of the claim that were previously subject to of ESA administrative proceedings. 2. The judicial nature of the decision. A common element of the preconditions to issue estoppel set out by Dixon J. and Engel is the fundamental requirement that decision in the prior proceeding be a judicial decision. According to the authorities, there are 3 elements that must be taken into account. First is to examine the nature of the administrative authority issuing the decision. Is it an institution that is capable of receiving and exercising adjudicative authority? Second, as a matter of law, is the particular decision one that was required to be made in a judicial manner? Thirdly, as a mixed question of law and fact, was the decision made in a judicial manner? These are distinct requirements. It is no avail to prove that the alleged re judica was a decision, or that it was pronounced according to judicial principles, unless it emanated from such a tribunal in the exercise of its adjudicative functions, nor is it sufficient that it was pronounced by such a tribunal unless it was a judicial decision on the merits. It is important, therefore, at the outset to have proper understanding of what constitutes a judicial tribunal and a judicial decision for the present purposes. As to the third aspect, whether or not the particular decision in question was actually made in accordance with judicial requirements, I know that the recent ex cura statement of Hanley J., the current editor of the Doctrine of Res Judica, said that the prior judicial, arbitral, or administrative must have been made within the jurisdiction before it can give rise to res judica estoppels. The main controversy in this case is directed to this third aspect, i.e., is it a decision to take in without regard to requirements of notice and an opportunity to be heard capable of supporting an issue estoppel? In my opinion, the answer to this question is yes. A. The institutional framework. The decision relied on by Rosenberg J.A. in this respect relates to the generic role and function of the ESA officer. Read Downing and Graydon Supra per Blair J.A. at page 305. In the present case, the Employment Standards Officer have the power to adjudicate as well as to investigate. The investigation is made for the purpose of providing them with information on which to base the decision they must make. The duties of the Employment Standards Officers embrace all the important indica of the exercise of judicial power, including the ascertainment of facts, the application of the law to those facts, and the making of a decision which is binding upon the parties. Parties do not dispute that ESA officers could properly be given adjudicative responsibilities to be discharged in a judicial manner. An early legislative limit of $4,000 of unpaid wages, excluding severance pay and benefits payable under pregnancy and parental provisions, was eliminated in 1991 by SO 1991 C16 S91. But the subsequent to the ESA decision in the present case, a new limit of $10,000 was imposed. This is the same limit as imposed on the Small Claims Court by the Court of Justice Act. B. The nature of the ESA decision under Section 65(1). An administrative tribunal may have been may have judicial as well as administrative or ministerial functions, so may an administrative officer. One distinction between administrative and judicial decisions lies in the differentiating adjudicative from investigative functions. In the latter mode, the ESA officer is taking the initiative to gather information. The ESA officer acts as a self-starting investigator who is not confined within the limits of the adversarial process. The distinction between investigative and adjudicative powers is discussed in Gouet v. Leffer. The inapplicability of issue estoppel to investigations is noted by Diplock L.J. in Thode v. Thode. At page 197. Although ESA officers may have non-adjudicative functions, they must exercise their adjudicative functions in a judicial manner. While they utilize procedures more flexible than those that apply in the courts, their decisions must be based on finding of fact, the application of an objective legal standard to those facts. This is a characteristic of a judicial function. The adjudication of the claim, once the relevant information has been gathered, is of a judicial nature. C. Particulars of the decision in question. The Ontario Court of Appeal concluded that the decision of the ESA officer in this case was in fact reached contrary to the principles of natural justice. The appellant had neither notice of the employer's case nor an opportunity to respond. The appellant contends that it is not enough to say that the decision ought to have been reached in a judicial manner. The question is, was it decided in a judicial manner in this case? There is some support for this view in Rasanen Supra per Abella J.A. at page 280. As long as the hearing process in the tribunal provides parties with an opportunity to know and meet the case against them, and so long as the decision is within the tribunal's jurisdiction, then regardless of how closely the process mirrors a trial or its procedural antecedents, I can see no principled basis for exempting issues adjudicated by tribunals from the operation of issue estoppel and a subsequent claim. Trial level's decision in Ontario subsequently adopted this approach. A statement in Muniel v. Sears Canada, Inc. reflects that position. The plaintiff relies on Rasanen and other similar decisions to assert that the principle of issue estoppel should apply to administrative decisions. This is true only where the decision is the result of a fair, unbiased adjudicative process where, quote, the hearing process provides parties with an opportunity to know and to meet the case against them, end quote. In Wong Supra, the Alberta Court of Appeal rejected an attack on the decision of an employment standards review officer and held that the ESA decision was adequate to create an estoppel as long as, quote, the appellant knew of the case against him and was given an opportunity to state a position, end quote. In my view, with respect, the theory that a denial of natural justice deprives the ESA decision of its character as, quote, a judicial decision, end quote, rests on a misconception. Flawed the justice may be, but judicial, as distinguished from administrative or legislative, it remains. Once it is determined that the decision-maker was capable of receiving and exercising adjudicative authority and that the particular decision was one that was required to be made in a judicial manner, the decision does not cease to have that character judicial because the decision-maker erred in carrying out his or her function. As early as R.V. Nat Bell Liquors, it was held that a conviction entered by an Alberta magistrate could not be quashed for lack of jurisdiction on the grounds that the deposition showed that there was no evidence to support the conviction or that the magistrate misdirected himself in considering the evidence. The jurisdiction to try the charges was distinguished from alleged errors in, quote, the observance of the law in the course of its exercise, end quote. If the conditions precedent to the exercise of a judicial jurisdiction are satisfied, as here, subsequent errors in this exercise, including violations of natural justice, render the decision voidable, not void. The decision remains a judicial decision, although seriously flawed by the want of proper notice and the denial of the opportunity to be heard. I mentioned at the outset that estoppel per rem judicatem is closely linked to the rule against collateral attack and indeed to the principles of judicial review. If the appellant had gone to court to seek judicial review of the ESA officer's decision without first following the internal administrative review route, she would have been confronted with the decision of this court in Harkin Supra. In that case, a university student failed in his judicial review application to quash the decision of a faculty committee of the University of Regina, which found his academic performance to be unsatisfactory. The faculty committee was required to act in a judicial manner, but failed, as here, to give proper notice and an opportunity to be heard. It was held that the failure did not deprive the faculty committee of its adjudicative jurisdiction. Its decision was subject to judicial review, but this was refused in the exercise of the court's discretion. Adoption to the appellant's theory in this case would create an anomalous result. If she is correct that the ESA officer stepped outside her judicial rule and lost jurisdiction for all purposes, including issue estoppel, the Harlequin barrier to judicial review would be neatly sidestepped. She would have no need to seek judicial review to set aside the ESA decision. She would be, on her theory, entitled as of right to have it ignored in her civil action. The appellant's position would also create an anomalous situation under the rule against collateral attack. As noticed by the respondent, the rejection of issue estoppel in this case would constitute, in a sense, a successful collateral attack on the ESA decision, which has been impeached neither by administrative review nor judicial review. On the appellant's theory, an excess of jurisdiction in the course of the ESA proceeding would prevent issue estoppel, even though Mabrum Supra says that an act in excess of a jurisdiction which the decision maker initially possessed does not necessarily open the decision to collateral attack. It depends, according to Mabrum, on which form the legislator intended the jurisdictional attack to be made in, the administrative review forum or the court, paragraph 49. It seems to me that the unsuccessful litigant in administrative proceedings should be encouraged to pursue whatever administrative remedy is available. Here, it is worth repeating, she elected the ESA forum. Employers and employees should be able to rely on ESA determinations unless steps are taken promptly to set them aside. One major legislative objective of the ESA scheme is to facilitate a quick resolution of termination benefits so that both employee and employer can get on with their things. Whereas here, the ESA issues are determined within a year, a contract claim could nevertheless still be commenced thereafter in Ontario within 6 years of the alleged breach, produce a lingering 5 years of uncertainty. This is to be discouraged. In summary, it is clear that an administrative decision which is made without jurisdiction from the outset cannot form the basis of an estoppel. The conditions precedent to the adjudicative jurisdiction must be satisfied. Where arguments can be made that an administrative officer or tribunal initially possessed the jurisdiction to make a decision in a judicial manner, but erred in the exercise of that jurisdiction, the resulting decision is nevertheless capable of forming the basis of an estoppel. Alleged errors in carrying out the mandate are matters to be considered by the court in the exercise of its jurisdiction or discretion. This result makes the principle governing estoppel consistent with the law of governing judicial review in Harlequin, Supra, and collateral attack in Mabrum. Where I differ from the Ontario Court of Appeal in this case is in its conclusion that the failure of the appellant to seek an administrative review of the ESA officer's flawed decision was fatal to her position. In my view, with respect, the refusal of the ESA officer to afford the appellant proper notice and the opportunity to be heard are matters of great importance in the exercise of the court's discretion, as will be seen. I turn now to the 3 preconditions to issue estoppel as set out by Dixon J. and Angle Supra at page 254. Issue estoppel applying the tests. A. That the same question has been decided. A cause of action has traditionally been defined as comprising every fact which it would be necessary for the plaintiff to prove, if disputed, in order to support his or her right of the judgment of the court. Salvaging each such fact, sometimes referred to as material facts, constitutes a precondition to success. It is apparent that different causes of action may have one or more material facts in common. In this case, for example, the existence of an employment contract is a material fact common to both the ESA proceeding and to the appellant's wrongful dismissal claim in court. Issue estoppel simply means that once a material fact, such as a valid employment contract, is found to exist or not to exist by a court or tribunal of competent jurisdiction, whether on the basis of evidence or admissions, the same issue cannot be litigated in subsequent proceedings between the same parties. The estoppel, in other words, extends to the issues of fact law and mixed fact and law that there are necessarily bound up with the determination of that issue in the prior proceeding. The parties are agreed here that the same issue requirement is satisfied. In the appellant's wrongful dismissal action, she is claiming $300,000 in unpaid commissions. This puts in issue the same entitlement as was refused to her in the ESA proceeding. One or more of the factual or legal issues essential to this entitlement were necessarily determined against her in the earlier ESA proceeding. If issue estoppel applies, it prevents her from asserting that the adverse findings ought to now be found in her favor. B. The judicial decision which is said to create the estoppel was final. As already discussed, the requirement that the prior decision be judicial as opposed to administrative or legislative is satisfied in this case. Further, I agree with the Ontario Court of Appeal that the employee not having taken advantage of the internal review procedure, the decision of the ESA officer was final for the purposes of the Act and therefore capable in the normal course of events of giving rise to an estoppel. I've already noted that in this case, unlike Herlican Supra, the appellant had no right of appeal. She could merely make a request to the ESA director for review by an ESA adjudicator. While this may be a factor in the exercise of the discretion to deny issue estoppel, it does not affect the finality of the ESA decision. The appellant could fairly argue on a judicial review application that unlike Herlican, she had no, quote, adequate alternative remedy, end quote, available to her as of right. The ESA decision must nevertheless be treated as final for present purposes. C. That the parties to the judicial decision or their privies were the same person as the parties to the proceeding in which the estoppel is raised or their privies. This requirement assures mutuality. If the limitation did not exist, a stranger to the earlier proceeding could insist that a party thereto be bound in subsequent litigation by the findings in the earlier litigation, even though the stranger, who became a party only to the subsequent litigation, would not be. Mutuality requirement was subject to some critical comment by McEachern CJBC while sitting as a trial judge in Saskatoon Credit Union Ltd v. Central Park Enterprise Ltd. It has been substantially modified in many jurisdictions in the United States. The concept of privity, of course, is somewhat elastic. I learned editors of J. Sopinka, S.N. Letterman, and A.W. Bryant in the Law of Evidence in Canada at page 1088 say, somewhat pessimistically, that, quote, it is impossible to be categorical about the degree of interest which will create privity, end quote, and that determinations must be made on a case-by-case basis. In this case, the parties are identical and the utter limits of, quote, mutuality, end quote, and the, quote, same parties, end quote, requirement need not further be addressed. I conclude that the preconditions to issue estoppel are met in this case. 4. Exercise of the discretion. The appellants submit that the court should nevertheless refuse to apply estoppel as a matter of discretion. There is no doubt that such discretion exists. General Motors of Canada Ltd. v. Nakin. SDJ noted at page 101 that the context of court proceedings, quote, such a discretion must be very limited in application, end quote. In my view, the discretion is necessarily broader in relation to the prior decisions of administrative tribunals because of the enormous range and diversity of the structures, mandates, and procedures of administrative decision-makers. In Bugbusters Supra, Finch J.A., now CJBC, observed at paragraph 32, it must always be remembered that although the three requirements for issue estoppel must be established before it can apply, the fact that they may be satisfied does not automatically give rise to its application. Issue estoppel is an equitable doctrine and, as can be seen from the cases, is closely related to abuse of process. The doctrine of issue estoppel is designed as an implement of justice and a protection against injustice. It inevitably calls upon the exercise of judicial discretion to achieve fairness according to the circumstances of each case. Apart from noting parenthetically that estoppel per rem judicatum is generally considered a common law doctrine, unlike promissory estoppel, which is clearly equitable in origin, I think this is a correct statement of law. Finch J.A.'s dictum was adopted and applied by the Ontario Court of Appeal in Sewanee Supra at paragraphs 38 and 43. The discretion to refuse to give effect to issue estoppel becomes relevant only where the three prerequisites to the operation of the doctrine exist. The exercise of the discretion is necessarily case-specific and depends on the entirety of the circumstances. In exercising the discretion, the court must ask, is there something in the circumstances of this case, such as the usual operation of the doctrine of issue estoppel, would work an injustice? ... The discretion must respond to the realities of each case and not to abstract concerns that arise in virtually every case where the finding relied on to support the doctrine was made by a tribunal and not a court. See also Braithwaite Supra at paragraph 56. Courts elsewhere in the Commonwealth apply similar principles. In Arnold v. National Westminster Bank plc, the House of Lords exercised its discretion against the application of issue estoppel arising out of an early arbitration per Lord Keith of Kinkle at page 50. One of the purposes of estoppel being to work justice between the parties, it is open to courts to recognize that in special circumstances, inflexible application of it may have the opposite result. In the present case, Rosenberg J.A. noted in passing at page 248 to 49 the possible existence of a potential discretion, but with respect, he gave it short shrift. There is no discussion or analysis of the merits of the case. He simply concluded at page 256. In summary, Miss Burke did not accord this appellant natural justice. The appellant's recourse was to seek review of Ms. Burke's decision. She failed to do so. That decision is binding upon her employer. In my view, it was an error of principle not to address the factors for and against the exercise of the discretion which the court clearly possessed. This is not a situation where the court is being asked by an appellant to substitute its opinion for that of the motion judge or the Court of Appeal. The appellant is entitled to some stage to appropriate consideration of the discretionary factors, and to date this has not happened. The list of factors is open. They include many of the same factors listed in Mabrum in connection with the rule against collateral attack. Similarly helpful list was produced by Laskin J.A. and Minot Supra. The objective is to ensure that the operation of issue estoppel promotes the orderly administration of justice, but not at the cost of real injustice in the particular case. 7 factors discussed below are relevant in this case. A. The wording of the statute from which the power to issue administrative orders derives. In this case, the ESA includes Section 6.1, which provides that no civil remedy of an employee against his or her employer is suspended or affected by this act. This provision suggests that, at the time, the Interior Legislature did not intend ESA proceedings to become an exclusive forum. Recent amendments to the Act now require an employee to elect either the ESA procedure or the court. Even prior to the new amendments, however, a court could properly conclude that relitigation of an issue would be an abuse. While it is generally reasonable for defendants to expect to be able to move on with their lives once one set of proceedings, including any available appeals, has ended in rejection of liability here, the appellant commenced her civil litigation against the respondents before the ESA officer reached a decision, as was clearly authorized by the statute at that time. Thus, the respondents were well aware in law and in fact that they are expected to respond to parallel and some extent overlapping proceedings, the purpose of the litigation. The focus of an earlier administrative proceeding might have been entirely different from that of the subsequent litigation, even though one or more of the same issues must be implicated. In Bugbusters Supra, a forestry company was compulsorily recruited to help fight a forest fire in BC. It subsequently sought reimbursement for its expenses under BC Forests Act. The expense claim was allowed despite an allegation that the fire had been started by a Bugbusters employee who carelessly discarded his cigarette. Thus, if provided, would have disentitled Bugbusters for reimbursement. The Crown later started a $5 million negligence claim against Bugbusters for losses occasioned by the forest fire. Bugbusters invoked issue estoppel. The court, in the exercise of discretion, denied relief. One reason per Finch Day at paragraph 30 was that a final decision in the Crown's right to recover its losses was not within the reasonable expectation of either party at the time of those reimbursement proceedings under the Forest Act. Similar point was made in Razin Supra by Carthy J.A. at paragraph 290. It would be unfair to an employee who sought an immediate and limited relief of $4,000, forsaking discovery and representation in doing so, to then say that he is bound to the result as it affects a claim for 10 times that amount. A similar qualification is made in the American Restatement of the Law, Second Judgment 2D, which refers to procedural elements as may be necessary to constitute the proceeding a sufficient means of conclusively determining that the matter in question, having regard for the magnitude and complexity of the matter in question, the urgency with which the matter must be resolved, and the opportunity of the parties to obtain evidence and formulate legal contentions. I am mindful, of course, that here the appellant chose the ESA forum. The counsel for the respondent justly observed with some exasperation. As the record clearly makes, Danyluk was represented by legal counsel prior to, at the time of, and the subsequent to cessation of her employment. Danyluk and her counsel were well aware of the fact that Danyluk had an initial choice of forums with respect to her claim for unpaid commissions and wages. Nevertheless, the purpose of the ESA is to provide a relatively quick and cheap means of resolving employment disputes. Putting excessive weight on the ESA decision in terms of issue estoppel would likely compel the parties in such cases to mount a full-scale trial-type offense and defense, thus tending to defeat the expeditious operation of the ESA scheme as a whole. This would undermine fulfillment of the purpose of the legislation. C. The availability of an appeal. This factor corresponds to the adequate alternative remedy issue in judicial review. Here, the employee had no right of appeal, but the existence of potential administrative review and her failure to take advantage of it must be counted against her. D. The safeguards available to the parties in administrative procedure. As already mentioned, quick and expeditious procedures suitable to accomplish the objectives of ESA scheme may simply be inadequate to deal with the issues of fact or law. Administrative bodies, being masters of their own procedures, may exclude evidence the court thinks probative or act on evidence the court considers less than reliable. If it has done so, this may be a factor in the exercise of the court's discretion. Here, the breach of natural justice is a key factor in the appellant's favor. Morden ACJO pointed out in his concerning judgment of Rasanen Supra at paragraph 295, quote, I do not exclude the possibility that the deficiencies in the procedure relating to the first decision could properly be a factor in deciding whether or not to apply issue estoppel, end quote. Laskin made a similar point in Midnote Supra at page 341 to 42. E. The expertise of the administrative decision maker. In this case, the ESA officer was not legally trained individual asked to decide a potentially complex issue of contract law. The rough and ready approach suitable to get things done in the vast majority of ESA claims is not the expertise required here. A similar factor operates with respect to the rule against collateral attack. Where an attack on an order is based on considerations which are foreign to an administrative appeals tribunal expertise or raison d'etre, this suggests, although it is not conclusive itself, that the legislature did not intend to reserve the exclusive authority to rule on the validity of an order to that tribunal. F. The circumstances given rise to the prior administrative proceedings. In the appellant's favor, it may be said that she invoked the ESA procedure at a time of personal vulnerability with her dismissal looming. It is unlikely the legislature intended a summary procedure for smallish claims to become a barrier to closer consideration of more substantial claims. The legislature's subsequent reduction of the monetary limit of an ESA claim to $10,000 is consistent with this review. As Laskin pointed out in Midnote Supra, employees apply for benefits when they are most vulnerable immediately after losing their job. Urgency, with which they must invariably seek relief, comprises their ability to adequately put forward the case for benefits or to respond to the case against them. On the other hand, in this particular case, it must be said that the appellant, with or without legal advice, included her ESA claim, the $300,000 commissions, and she must shoulder at least part of the responsibility for her resulting difficulties. G. The potential injustice. As a final and most important factor, the court should stand back and, taking into account the entirety of circumstances, consider whether the application of issue estoppel in this particular case would work in injustice. Rosenberg J.A. concluded that the appellant had received neither notice of the respondent's allegation nor an opportunity to respond. He was thus confronted with the problem identified by Jackson J.A. dissenting in Iron v. Saskatchewan Minister of the Environment and Public Safety. The doctrine of res judica, being a means of doing justice between the parties in the context of the adversarial system, carries within its tenets the seeds of injustice, particularly in relation to issues of allowing parties to be heard. Whatever the appellant's various procedural mistakes in this case, the stubborn fact remains that her claim to commissions was worth over $300,000, simply never been properly considered and adjudicated. On considering the cumulative fact of the foregoing factors, it is my view that the court, in its discretion, should refuse to apply issue estoppel in this case. V. Disposition. I would therefore allow the appeal with costs throughout.